decent number. I gave a talk a couple of weeks ago about COVID-19 and the English law of contract and what we could learn in terms of how contract law will approach the various challenges that might be thrown up by COVID-19. What I want to do this evening is to look at the law of damages. The loose topic for discussion is making China pay. And I don't mean to be flippant on that. I mean, there is a lot of discussion globally, and certainly in the UK, I've seen it in the US as well, as to how, once all of this is out of the way, how we pay for all the economic mess that COVID-19 has caused, and more importantly, who we should get to pay for it. Because at the moment, there are taxpayers and businesses all over the world faced with a very, very large bill. So what I want to do is two things. First of all, I want to start off with some context and actually go through the detail of the current pandemic. So I think that's important. I think it's important for a number of reasons. As lawyers, if people going into practice, law turns on the facts a lot. A lot of these cases that we come across are going to be different. They're going to involve different people, different circumstances. So actually understanding the facts is step one to any coherent and cogent legal analysis. Once we've done that, I want to very briefly give an overview of the sorts of remedies that might exist, both internationally and domestically. And then finally, I want to sort of focus and drill down on the English law of damages and what approach the courts take in England to assessing how much a defendant who's been found liable for a breach of contract or a tort, assessing how much they should pay for that breach. Okay, so I think, as I say, the first thing I want to do is talk a bit about the pandemic, about the strange situation we find ourselves in. And when I'm approaching any legal problem, I think the first thing that I do is I get out a pad or I get a spreadsheet and I try and make a chronology of events to work out what has happened and how it all fits together. And I won't do this exhaustively, but it's worth recapping where we are in the pandemic and where we've come from. And the story actually begins earlier than I thought it did. The story begins on the 17th of November 2019. There is some record that the first case of a virus matching the description of COVID-19 was found in Hubei province in China in a 55-year-old man in November last year. The Lancet then fast forward to 1st of December when the first known COVID-19 case was recorded. And throughout December, there's this trickle of news stories in China about patients presenting with a fairly unusual and unknown type of pneumonia. Now, I think from my records, the first, so four cases ended up in hospital on December the 26th. They reported on December the 27th. A further 3 presented over the 28th and 29th. And the key issue here is on the 30th of December, this very brave Chinese doctor, Li Wenliang, starts to try and report these outbreaks of this sort of strange pneumonia type illness. But instead of that being recorded, he, as we all now know, was investigated by the police and forced to sign a pledge that he wouldn't spread any disruptive rumours. And that's important for a reason we'll come on to in a moment. But continuing with the chronology for a moment, if I can get it up again. Apologies, 2 seconds, here we go. So continuing with the chronology, the seafood market was shut on January the 1st, but it wasn't until late January, I think January the 30th, that the World Health Organization declared a global health emergency as a result of COVID-19. So that's kind of some sort of month and a half after arguably the first, perhaps even longer than a month and a half after the first case presents itself. Now, this obviously will be relevant when we come to it, but what we do know, therefore, is that there was knowledge in China of this virus for some time before official reports were made to the external world. And that is potentially relevant when we come on to talking about damages and assessing those sorts of things, because there seems to be now a consistent set of evidence that, one, China didn't report early, two, on the 31st of December, it stated there was no clear evidence of human-to-human transmission in circumstances where it believed that there were. And in fact, it confirmed that human-to-human transmission was possible only in later January. So that kind of sets the chronological sort of context here. Just as interesting and important is to understand the profile of the virus itself, because it's okay kind of looking and saying who's at fault, what's happened, who's caused what. But actually, it's also important and necessary to kind of quantify the thing, if we can call it that, the thing that is causing the damage. And in this regard, if I can get to my note on this, one of the key things about COVID-19 that's made it sort of quite have such an impact is it's quite stealthy. It doesn't present itself in patients for a long time. It sort of, people can carry it, people can be infected and not really sort of present any data of being infected. There are some kind of questions as well that arise from all of this. I mean, the key one at the moment seems to be there's increasing evidence that being infected doesn't necessarily confer immunity. There are kind of examples around the world right now of patients being infected a second time. So that gives us some idea as to the nature of the virus. And looking forward, well, not even looking forward, we're in May now. Is this a different phenomenon to, for example, to seasonal flu, which sees a kind of flattening of the curve in the summer? Again, there seems to be no real evidence there that the summer is going to be helpful for us in terms of slowing the pace of all this down. So that's the background and the virus. And again, I don't want to go into too much detail about responses, but certainly in the UK and definitely in the US, there's been what can only be described as a slightly flat-footed response by governments and officials to the crisis. First, sort of underplaying the scale of it, and then second, sort of arguably taking steps a little bit too late. I mean, in the UK, we had the example of Italy and Spain several weeks ahead of us, yet seemingly have not done anything in the meantime to be able to learn from those examples. And I think the UK now is headed to be one of, if not the worst affected country in Europe. And again, these sort of factual issues are important when one comes to assessing damage, because it's not just, as we'll come on to look at, it's not just about causation and who's caused what's happened, but there are questions about, has there been any contributory negligence, and also whether the affected party has done enough to mitigate their loss. So there are, and I just flagged them there for the time being, because it's all important factual context. The most important data is the sheer impact that this virus is having on businesses and individuals all around the world. I was looking at the data on this earlier, and I'm just trying to get the relevant tables and graphs up now. But the economic impact is absolutely astonishing. And I'll read from this sort of verbatim. I mean, this is from a set of slides that were prepared about a month ago, so about a month out of date, but they're still fairly good. So looking first in terms of the economic consequences on supply chains, the worst impact here is likely to be. Oops, I'm just looking at the Q&A in the chat. The worst hit sector here, and we'll go into some specific numbers on this, but the worst hit sector is likely to be tourism and hospitality. And most projections at the moment have tourism and hospitality not returning to anything like a global restart until the fourth quarter of this year. And if anything, I think that's optimistic. And I've been looking at discrete companies, but for example, Norwegian Airlines, I saw projections the other day, and it's a company that does a lot of flights long haul to the US. I think they're not expecting to resume a normal timetable until the summer of 2022, so 2 years. So there's going to be a long tail to this. Similarly, aviation airlines, Q4, we're not going to see, on a lot of sort of projections, a return to some form of global restart on this. The automotive sector, oil and gas, we're looking at the third quarter. And I'll come on to oil and gas, specific issues with that in a moment. And then maybe consumer products and electronics will kind of bounce back a bit quicker. But one of the things this crisis has really laid bare is, for large parts of the economy, how reliant they are on a global supply chain. And when analysing this kind of both factually and legally, the scope for sort of cascading losses is fairly large. So taking air traffic as one example, in the first half of 2022, so in the first few months of 2022, sorry, there's been a 10% drop in global air traffic, which is the biggest decline ever. There's also kind of been a knock-on effect of that. And for example, Chinese tourists spend 18 billion a year in Thailand. If they're not traveling, that's not going to be spent. There's a whole range of other sort of people who drive. So 150 million Chinese people travel abroad annually. They're quite big spenders. So that's going to have an impact on a lot of economies outside of China. And again, looking at the numbers on all of this, the United States tourism spending from other countries in the US is about 6-7% of its gross domestic product. In the UK, it's higher, it's about 7%. And looking at how much of those sectors employ as a percentage of the overall workforce. In America, about 5% of the overall workforce, and a similar number in the UK, are reliant on tourism. And you look at countries like Spain, it goes up to 13% of the workforce. Italy is kind of close to 10. So there are going to be, as I say, long tail effects here that we're going to live with for a while. And we saw part of this a few weeks ago with the oil markets and the fact that oil futures went negative for the first time ever. That is to say that if I had a futures contract to buy a barrel of oil in a month's time, people were actually going to pay me to take oil off them rather than me pay them for the oil, which is extraordinary. I mean, partly that can be explained by a range of factors, including lack of supply capacity, and there's a bottleneck in oil storage in the US. But the drop in global demand for a whole range of things is going to be with us for a very long time. And that filters through to things like US unemployment rates. And I'm sure this is going to be the same in a lot of countries, but it's quite astonishing how much US unemployment has peaked. I think it went from less than 1 million unemployment claims in the beginning of 2020 to close to 7 million in mid-April, which is an absolutely astonishing peak. And then you look at business surveys as to how long all of this is going to take to get back to normal, and people are very, very pessimistic about the amount of time this is going to take. So that's all that. You then look at financial markets and the effect all of this is having on currencies. The US dollar is now very strong, which has a range of knock-on effects because people are fleeing to certain types of bond. That again is making US debt very cheap at the moment. But the flip side, as I understand it, is a lot of other countries who would ordinarily be refinancing their debt around now over the next few months are going to find it very, very difficult to access global capital and debt. So not only are individuals and businesses starting to feel the pinch, but there is the very real prospect of a sovereign debt crisis where countries are no longer able to pay the bills because they can't raise the money they need to do that. So that all basically paints a very bleak picture. And you look at the steps that countries are taking to mitigate some of this damage. US Congress has passed a package of relief of worth $2 trillion US, like $2 trillion, a huge amount of money. In the EU, George Soros has proposed an issue of a perpetual bond to meet the cost in the Eurozone. I think that's been estimated at around $1 trillion in terms of the damage that this is going to cause. And there's a Henry Jackson Society report, which I'll share the PDF and the link to that after the talk. There's a Henry Jackson Society report in April that looked at a lot of this. And it looked at the cost just to G7 countries alone. And that came out at £3.2 trillion, so about $4 trillion US. So these are big amounts of money. This is we keep hearing superlatives about how big a crisis this is. It's the biggest crisis in 100 years, biggest crisis in a generation. I heard someone say the other day it's the biggest recession for 300 years. The key point is this huge crisis is going to have a long tail effect, and there are going to be huge, huge costs associated with it. So as lawyers, people are going to be coming to us and saying, look, well, who should be picking up the bill here? And that is an important question. And the reason I took some time setting out the various bits of background on this, that maybe mid-November, maybe early December, these first cases came to light in China. There was a University of Southampton study a few months ago that seemed to find evidence to suggest that if China had taken the measures it finally took 3 weeks earlier, that is to say at the end of December rather than sort of over halfway through January, there would have been 95% fewer cases globally, 95% fewer. And even if it was 1 week earlier, there would have been a reduction of about 66%. So the starting point, and that's why we're seeing around the globe this backlash towards China, is the starting point is that this has originated in China. Whether it's come from the wet markets or Virology Institute, that remains to be determined. But there seems to be an argument here that a degree of negligence on the part of the Chinese government has amplified, whether the initial pandemic outbreak was a fault, there is arguably a flaw and a fault that arises from the government's inaction and its attempts to cover this all up for 3 weeks that has led to a massive magnifying of the impact that this crisis has had. So as lawyers, and I kind of say this time and time again to the lawyers I work with, the key question that I think we have to ask ourselves is, yes, all this is very important. Yes, all this is very costly. And yes, we can sympathize with businesses that are going bankrupt, people who are losing loved ones, countries that are unable to pay the bills. But what's the consequence of all this? So what? How do we, as lawyers, assess whether there are any remedies here for potential clients? And there's been some work already that's gone into this. The Henry Jackson Society report that I talked about earlier has looked at a variety of potential mechanisms by which to hold China and the Chinese government to account. And they broadly break down into sort of international remedies and domestic ones. Just have a sip of my tea while I find the report. And so the international remedies under international law, they have suggested there are at least 4 possible avenues that could be taken here. The first is something called the International Health Regulations, which date back to 2005. And under the international health, there are various obligations created on that, but one of those is an obligation to report. And under this route, it's basically suggested that there has been a failure, a breach of an obligation to report this illness when it first became known about in December, and consequently that leads to an actionable wrong under the international health regulations. And this report then goes on to suggest there are 2 possible forums, the Permanent Court of Arbitration in The Hague or the International Court of Justice. Now, and this is a point that applies to all the international remedies. There are a lot of issues in following this kind of route, to me, as a lawyer. One, international law remedies take a long time to access. Anyone who's involved, as I am, in investor state work, for example, knows that these cases can go on for a very long time. And then at the end of it, there is often, not always, often a real issue as to how you enforce it, because countries, even if they're found to be in the wrong and have to pay lots of money, understandably, it's with absent an enforcement mechanism to force countries to pay, one has to rely on them having assets in jurisdictions where enforcement is possible. So that's a problem with all of that. Another suggested route is through the World Trade Organization, because that has dispute resolution mechanisms, etc., etc. But again, timing is going to be a huge issue there, and the WTO at the moment, as a matter of politics, just doesn't seem to be functioning very well. Another form of international law remedy, which may have a bit more teeth, is bringing an action under a bilateral investment treaty, say an investor state claim. that relies on having an investor who's suffered some sort of loss as a result of the Chinese government's actions. And that's not necessarily going to be an easy find in and of itself. So from my point of view, there are obvious kind of merits to all of these approaches, but taking an international law approach is not necessarily going to be one that delivers a speedy remedy or speedy resolution. So that brings us to the heart of this talk, which is the English law of damages and what domestic remedies there may or may not be in the UK to recover some of the losses that have been incurred as a result of COVID-19. And even there, the starting point is not a promising one, because the UK, like a lot of jurisdictions, adheres to the doctrine of sovereign immunity. The UK has, in the form of a 1978 Act, a State Immunity Act. And Section 1 of that says very clearly, a state is immune from the jurisdiction of the courts of the United Kingdom except as provided in the following provisions of this Act. And there are exceptions, but they are quite narrow. So, for example, the first one is where a state voluntarily submits to the jurisdiction. Well, in circumstances where there's a huge amount of politics around COVID-19, it seems unlikely the Chinese government is going to want to submit to the jurisdiction of the UK courts, or indeed any courts. The other exemption is commercial transactions and contracts performed in the UK. So it may well be, and I haven't done any detailed analysis on this, but it may well be that some Chinese state-owned entities have entered into a range of contracts with companies in the UK that are to be performed in the UK. I don't necessarily sort of think that's an impossible find. And the UK, China has been investing in British infrastructure a lot recently. But then the question is well, is there any related loss as a result of COVID-19? That's going to be difficult. And there are a range of other exceptions, but they're all quite narrow. There is a overarching question as to whether the UK's 1978 Act is compatible with elements of human rights law, in particular Article 6, the right to a fair trial. But again, as a starting point, just as an advocate and a lawyer who finds himself sat in consultations with clients, it's not an attractive starting point for any client to say to them, well, it's a difficult area of law. We're starting from a presumption of immunity, but if we go through several years, lots and lots of money, and lots of levels of the legal system, we may, following an appeal, find that the immunity we're up against is a bit narrower than we first thought. It's not a promising proposition. So the starting point, as a matter of English law, is that state immunity is a real issue that any potential claimants are going to find very, very troublesome to overcome. So I could just end the lecture there, but that would be unfair. Let's, for the moment, put state immunity to one side and assume that there is an exception here, that we can, through the UK courts, reclaim, in principle, losses suffered as a result of wrongs by the Chinese government in relation to COVID-19. Now, there are some general principles as a matter of English law that are worth spelling out before going into this in the level of detail that I'd like to. The first is that as a general principle, this isn't university true, as a general principle, English law damages are compensatory and not punitive or non-compensatory. That is to say, they are recompensing someone for a loss. They're not punishment, they're not anything else. They are compensatory. And that, for example, is to be contrasted with the position in other jurisdictions where there can be triple damages, special damages, all sorts of tricks and procedural innovations to disincentivize certain types of behavior by making the liability incredibly punitive. That is not the starting point in England. And I want to look mainly at compensatory damages here because they're the most relevant to the question of COVID-19. And in any event, there's not time to do both compensatory and non-compensatory in the level of detail that I'd like. What I would say, and this sort of trips up quite a lot of non-English legal scholars, even English legal scholars sometimes actually, is there is, in terms of non-compensatory damage, there is a general principle as a matter of English law that, as follows from the idea that damages should be compensatory, that the penalty clauses will not be enforceable. That is to say, if in a contract I say, if in the event of a breach, if party B breaches, they, by reason of just breaching, have to pay a penalty because of that. That usually, and I'll unpack the reasoning behind that, the usual reasoning is that penalty clauses as such will not be enforceable. And the old rule used to be that the only circumstances a penalty clause would be enforceable is if it was a genuine attempt to pre-estimate the cost or the loss that would arise from the breach. And what that traditionally tends to mean is that the penalty sum couldn't be enforced if it so greatly exceeded the greatest amount of loss that could be proven to be caused by the breach that it could be sort of said to be extravagant or unconscionable. So that was the traditional position. The Supreme Court, I was going to say recently, but it's 5 years ago now, the Supreme Court in 2015 issued a case called in Cavendish Square Holding and MacDessie, also known as Parking I Limited and Beavis, where this issue of penalty clauses was revisited. And the Supreme Court in that case stated that the most important aspects of the penalty rule were as follows. First, the penalty rule isn't applicable to contractual provisions which stipulate an obligation to pay a certain amount of money or to suffer another form of detriment by way of a primary obligation. It's only applicable to a secondary obligation, i.e. an obligation that's triggered by a breach. So it's not a penalty clause if it's a primary obligation. So for example, say a guarantee or an indemnity, for example, where it's a primary obligation. The second point is the distinction between primary and secondary obligations is a question of form, not substance. What that means is even if the contract says this is a secondary or a primary obligation, that is not going to be determinative. What the court will want to look at is the substance of the actual obligation. Third, the question whether a particular clause is a penalty falls to be decided as a matter of objective interpretation, as at the time it was agreed. And therefore, the circumstances in which the clause falls to be enforced are irrelevant. So it's all about contractual interpretation, what we talked about last time, as at the date of the contract. So the true test is as follows. It's whether the clause is a secondary obligation which imposes a detriment on a contract rate out of all proportion to any legitimate interest. And that's the words used by the judgment. The general test can be described as whether the sum or remedy stipulated is exorbitant or unconscionable when regard is had to the innocent party's interest. The traditional test is based simply on a comparison between the stipulated amount and the greatest loss that could be proven to have been caused by the breach. The words extravagant and unconscionable usually mean the same thing. And in the context of a liquidated damages clause, an inability to ascertain what measure of damages might be appropriate can justify an agreement in advance to pay a fixed sum on breach. What that means is there may be circumstances that the parties contemplate at the time of making a contract that they agree that, well, look, it's just going to be too difficult to work out how much this breach will cost, so let's just agree a fixed sum. The final point, if the innocent party was able to dominate the contract breaker at the time of the contracting, the courts might take it into account when looking at enforceability. So kind of equality of arms at the point of contracting is relevant. So that's all I'm going to do on penalty clauses and sort of non-pecuniary losses as such. So I want to sort of look at compensatory loss. I want to look at the general principles of compensatory loss. And if and when you start to look at the case law around this, you'll see there's a whole muddle of labels and confusing terms that even practitioners and academics don't really have a handle on what they mean. So I'm going to try and avoid contentious labels. So one of the things, for example, you'll come across is this idea of general and special damages. And I was reading earlier today when preparing for this talk, one of the leading books on damages, McGregor on damages. And I think in McGregor, they say there are at least 3 competing meanings as to what general and what special damages may or may not be. So I will try and steer clear of that. The general outcome as a matter of English law, this isn't a hard and fast rule, but it's just kind of a practical reality, is that compensatory damages are often, and I say often, not always, compensatory damages are often less than the actual loss incurred. And that's by reason of a range of mechanisms we'll go on to look at that operate to limit recovery. They rightly seek to allow a wrongdoer to be sued, but at the same time, the courts in England and the way the case law has evolved is such to impose obligations on the innocent party, basically not to kind of be an accessory to any breach, not to contribute to any negligence, but also where something bad has happened, not just to sit back and think, well, I've got a nice monetary claim here, I don't have to do anything. There is a duty, as we'll go on to look at, to mitigate loss. So that is the starting point here. I say I won't use general or special damages as a label because they are ambiguous terms. What I want to look at is kind of damages as a matter of contract, because that will be relevant to you in practice, and then damages as a matter of some form of tortious breach or tortious trespass, because that's perhaps more relevant. So negligence, all those kind of things, more relevant to any kind of COVID-19 type assessment. So starting with contract law and how the kind of the very basic principles here. There is a case from, I think, the mid-19th century, Hadley and Baxendale, that they're still adhered to now, that sets out 2 limbs for assessing kind of what is generally recoverable as a matter of contractual breach. And the first of those is what's described as losses that flow from the breach, losses that are ordinarily caused by the breach. And they're sort of fairly easy to identify. So if the breach didn't happen, There's sort of things you can say, well, that loss wouldn't have happened. The second limb is slightly sort of more abstract, but it's losses that were in the reasonable contemplation of the parties at the time of contracting. What this is trying to do is operate to limit liability, because in terms of causation, and that can kind of go on forever and ever and ever. So there has to be some kind of limitation on what sorts of losses can in fact be recovered as a matter of contractual breach. So that's the starting point. Now, let's just get my notes back up. So, when we're looking at compensatory damages, the two categories I want to look at are pecuniary and non-pecuniary. So pecuniary basically means relating to money, so monetary loss, and a non-monetary loss that you nevertheless want to quantify in money terms. So they're the two categories I want to look at. So, starting with pecuniary loss as a matter of contract law. The normal measure of damages in these types of case is what's known as the loss of a bargain. What have I lost by reason of the breach? What should I have had the breach not have happened? And how can the court go about putting me in a position that I would have been in had that breach not happened? So that's the norm, what we call the normal measure of damages, or the expectation loss measure of damages. It's what I would have expected to be in receipt of had the breach not happened. And the types of benefits I could have expected to receive under a contract kind of fall into sort of three main types, really. So I could expect to receive some form of property under a contract. I could maybe expect to receive some form of money, or I could expect to receive some form of services. And similarly, there are probably sort of three basic forms of breach of contract. The most simple of those is non-performance, i.e. the other side just hasn't done what they were supposed to do. The second is delayed performance. They've done it, but it's late. And going back to the context of global supply chains and just-in-time manufacturing, if you are manufacturing a car, and there are a lot of studies actually done in Britain in the context of Brexit as to how many times the components of a car cross the English Channel between Britain and Europe and back, go backward and forward as the car is being assembled, the engine block, the gearbox goes back and forward. If you have a delay of a day, a week, a month in that context, it has knock-on effects that mean the car or whatever else is going to be much more difficult to manufacture. So delayed performance can be a huge issue in context of supply chains and elsewhere as well. Sometimes delayed performance doesn't matter though, whether it's a month late or not doesn't really have an impact. So you kind of have to assess the quality of the breach as well as the type. And the third type is defective performance. So I contracted with you to sell me a ship, to make and sell me a ship, but the ship you provided me, it's defective in some way. I want an oil tanker, but it leaks. I can't sail an oil tanker around the world with a tanker that leaks oil. So defective performance is an issue as well. So they're the kind of the broad types of breaches. So thinking about the normal measure of damages and being put in the position I should have been in had the contract been performed, you could kind of subcategorize these then. So the first loss that one can conceive of by reason of a breach of contract is a loss of use, a loss of profits, or a loss of interest. So a loss of use because the property hasn't been delivered, or the land hasn't been transferred to me, or etc., etc. Loss of profits because, again, my supply chain has been disrupted. I've not been able to sell the product that I was hoping the component I was buying would be a part of. You can see that there are a range of very simple things that, in principle, it's quite easy to quantify. And I say in principle because in practice, these things can get quite tricky. But the first point to say about the non-measured damages is you can recover gains that were prevented by the breach. One thing that I should sort of point out as well, that it's slightly less relevant to the COVID context, but given we're talking about damages anyway, it's quite rare as a matter of English law, but you can claim as under normal measures a loss of a future reputation. I mean, this is most common in sort of three subcategories. Say, for example, I'm an actor and my film studio wrongly fires me, and that causes me a loss of publicity. And without that publicity, without my name on the banner, I'm going to suffer a loss of profit in the future that it will be difficult to quantify, but it will not be impossible to quantify. Similarly, if there's been some form of defective performance of an advertisement contract, so I contract with an agency to advertise my wonderful product, they do it in a defective way that means that people think my product is rubbish, I can claim for the reputational loss there. But those kind of reputational losses are a lot rarer. So normally when we're looking at the gains prevented, we're looking at a loss of a profit, loss of an interest, or loss of use in what we were contracted to receive. The other element that we can recover under the normal measure of damages are expenses that were caused by the breach. So I will potentially say, for example, we're talking about the supply chain again, and we've got parts that need to arrive all on a certain day for me to manufacture things. And I can't wait for the part that I've contracted to arrive. Either it's not going to turn up or it's going to turn up late. So I have to spend money getting a replacement. Now, in principle, the costs caused to me in coping with this breach are recoverable, subject to some rules we'll go on to, but that is the starting point here. What is not recoverable in this context are the sorts of costs that I incurred in ordinary performance of the contract. We'll come on to why in a moment, but the general principle, and again, I'll reiterate this in a moment, but the general principle is against double recovery. That is to say, I can't get double the benefit, double the damages for a single breach. So if I'm looking to recover a cost, for example, that I've had to outlay on a replacement part, if that part then turns up later and I'm able to use it in a subsequent product, I can't claim the whole benefit of the cost for the initial replacement, because I'm going to have to net off the fact that I did still eventually receive some benefit from what I was contracted to receive. I mean, there may well be questions as to interest, questions as to a rush fee on getting something quickly, where so you can claim the delta, the difference between the two amounts. But double recovery, as a rule, is precluded as a matter of English law. So that's what I call the normal measure of loss as a matter of pecuniary losses under a contract. And as I say, the key point there is what the court is trying to do is put the wronged party in a position they would have been in had the breach not occurred. So sometimes it's called but-for damages. But for the breach, what position would I be in? What damages are I entitled to put me in the position I should be in today? So that's what's known as the ordinary measure of damages. There is an alternative under contract, which I'm going to call reliance loss. And in this context, what the court does is it doesn't say, how am I going to put you in the position you would have been in had the breach not occurred? What it does instead is it tries to ask, how, as a measure of damages, do I put you in a position you would have been in had you never, ever entered into the contract? So it's in this context that the sorts of costs that you spent in performing the contract as your side of it, so maybe it's buying a factory, putting in a production line, reconfiguring certain things. So costs that you incurred in your side of the bargain, if you're looking to recover on the reliance loss basis, then they become, as a rule, recoverable. But again, the flip side is that I can't seek to also recover costs that would put me in the position I would have been in had the contract been performed. And that's less of a hard and fast rule as today than it used to be, but we'll come on to that in a moment. But reliance loss, there are certain limitations to it. And it's perhaps worth going into this in a little detail, because the reason why would I usually want to go one way or the other? Now, in a lot of contracts, you're not going to want to recover on a reliance loss basis because you've entered the contract explicitly on the basis that you think you'll get out of it more than you're putting in. That's just commercial common sense, in a way, that I'm making an investment to get a return that is greater than that initial investment. So in a whole range of cases I've been involved in, especially, for example, pharmaceutical cases where there's been some form of breach that means I can't bring a drug to market. Well, potential drug sales are huge. So I would probably want, rather than kind of to recover the costs of building a factory to manufacture the drug and package it, I would probably, in those circumstances, want to get an expert to tell me what my likely future sales would be, and try to recover losses on the basis of what I would have been entitled to if the breaching party hadn't breached. But that's not always possible. So certain circumstances mean that a claimant has to go down the route of saying, well, I just want the money back that I put in, because it's just going to be too difficult, or various other reasons, but largely it's going to be too difficult for me to say what I would have got out of all of this. So one of the leading cases on this is a case called Anglia Television and Reed. And what happened in this case was the claimant was a television company, and it employed an actor who became the defendant in this case to play a leading role in a film. What happened then was the defendant repudiated the contract, he refused to perform, and the claimant, the TV studio, wasn't able to find a suitable substitute, so the film was abandoned. And in those circumstances, it was going to be very difficult, if not impossible, to prove what the profitability of the film would have been, i.e. what the measure of expectation loss would have been. So the question there was it possible for the TV studio instead to recover what it had spent to date? And it was, but the key point is that that's putting you, as I say, in a position that you would have been in had the contract never been entered into. There are a number of limitations on this as well. The chief amongst which is you won't be able to claim reliance type loss damages in circumstances where you've made what is just called a bad bargain. If the contract that you've entered into is enforceable, but just very, very unfair against you, in that you've it is just what is called a bad bargain, then in those circumstances, the court is going to be very reluctant to allow you to unwind that in your favour and just be put back in the position that you would have been in had you not incurred expenditure in entering into the contract. So that's the primary limitation on Reliance Loss. There are others, but I'm just conscious that I've been going through now. So I want to get on now to the tortious measure of damages, because that is important in the context of COVID-19. One thing I should say before I move on, I did highlight, I come on to this. I say under contract, a party has a choice to elect as between expectation loss and reliance loss, and that sort of became an unwritten rule that took sort of greater significance than it perhaps should have done. It's sort of a decision of the Court of Appeal in a case called Cullinane. And that came to stand for the proposition that one could only elect to recover damages on the expectation loss basis or on the reliance loss basis. The key point really here is that actually the main rule, and the reason that as a proposition usually is true, is this point that I said earlier about double recovery being precluded. You can't get the same money back twice in different ways. So don't be sort of tricked into thinking that you have to choose hard and fast expectation and reliance loss. But more often than not, that will be the election, the choice that any potential claimant is going to have to face when pleading out a claim. Okay, so that is as a matter of contract. Now, as a matter of tort, actually, pecuniary loss isn't necessarily as important, because more often than not in tort, it's going to be a question of non-pecuniary loss, i.e. injury, damage, all sorts of things that are kind of not strictly monetary. But let's quickly look at kind of pecuniary loss as a matter of tort. Just find my bit of a note. And just to sort of take a step back, actually, a tort in general terms is an invasion of some form. It's a trespass on your rights. So it can either be some form of nuisance, some form of negligence, some form of defamation or libel. There are statutory torts such as infringing intellectual property rights. But that's what I mean when I'm talking about a tort. And it's in terms of pecuniary loss, it's usually where me as claimant has lost something because my goods have been damaged, and something flows from that. So there can be damage, but I can also, in theory, again, recover expenses that a tort has caused me to incur. Again, there are limitations on that to keep it within reasonable bounds. I'll give you an example on this. So, for example, under statute, it's possible if there's been a wrongful death to recover funeral expenses. I've got to bury my relative. So that's just kind of one example there. So that is pecuniary loss as a matter of tort. I want to turn now, though, to non-pecuniary loss. I'll deal with that first as a matter of contract. It's less common as a matter of contract, but it does come up. the sort of non-pecuniary losses that one will face as a matter of contract law are actually kind of similar to the ones that one will get in tort, and we'll analyse them in a bit more detail under tort. But in broad terms, there are 5. So physical inconvenience and discomfort, pain, suffering, loss of amenity, 3, mental distress, 4, social discredit, which is quite a sort of odd one. I'm just trying to find the 5th one now. Sorry, there are only 4. My bad. Okay. So let's look at, because this kind of makes this is relevant then to the discussion of negligence and COVID-19 and acts of the Chinese state. What losses and damages in principle are recoverable as a matter of English tort law? So the first one I mentioned is pain, suffering, loss of amenity. And that's, again, it's an easy one to envisage in the context of an infectious illness that has been given to you by some form of let's kind of, because of the sort of negligence. So someone's negligence has made me sick. Well, I am going to suffer a degree of pain, a degree, perhaps a loss of a sort of function as a result of that. So maybe because I'm paralyzed in some way or whatever. So those sorts of losses are recoverable as a starting point. And sort of quantifying them is often quite difficult. And again, as a matter of English personal injury law, there are a whole range of tables that set out sort of fairly macabre sort of sums in terms of how much a loss of a finger is, how much a broken leg is, etc., etc. But those sorts of things are recoverable. One can also recover for physical inconvenience and discomfort. How is that different from pain, suffering, loss of amenity? Well, that basically is something that is falling short of pain and discomfort. So it's just some form of inconvenience. So, for example, the tort of false imprisonment causes me an inconvenience, but doesn't cause me pain, sort of loss and suffering, unless I've really been imprisoned in a fairly horrible way. Another sort of head of non-pecuniary loss as a matter of tort law is social discredit. And this is probably most relevant to the tort of defamation, where someone says something about me which makes people think less of me. And again, there are kind of a whole range of issues as to properly quantifying that. But in a COVID-19 situation, will we see sort of various kind of Chinese state actors looking to enforce their rights if they feel that they're being libelled or defamed by things being said about them? The UK has long been seen, rightly or wrongly, to be an attractive forum for people to bring defamation claims, because it historically has been quite good for sort of libel tourism, as it's called. But whether we actually see that in practice remains to be seen. The other issue is mental distress. So again, quantifying mental distress is quite difficult, and it's generally not sufficient in and of itself. But it is possible under certain heads of injury to kind of add mental distress in as a recoverable loss. So in general terms, it's possible where I have been wronged in tort to recover for those kind of things that tort has caused me to suffer, whether it's a loss of reputation, social discredit, or physical injury. And that's probably common in many jurisdictions, but it's worth bearing in mind in the COVID-19 context, because there are unfortunately going to probably be further deaths, fatalities around the world. And is that something that that we should be looking at advising people to sue in England the Chinese state in respect of? As I say, probably not, for the reason I said kind of halfway through. The main problem here is going to be state immunity, and the key issue with all of this, in terms of making China pay narrative, and this is sort of the take-home point from this talk, if you like, is whether it's in America with US senators saying we're going to cancel part of our debt to China, whether it's the US government talking about sanctions or tariffs, whether it's US states and attorneys general looking to sue. I think Missouri as a state, for example, is looking to sue China, which again is going to come up against sovereign immunity issues. Whether it's the Henry Jackson Society saying let's go internationally under the international health regulations or under an investor treaty. Whether it's in the UK looking to sue for negligence, loss of life, injury, damage, contractual losses that flow from all of this. The ultimate question actually, I think, isn't a legal one, it's a political one. It's political in the sense that most of international legal norms are a function of the global political system, whether that is the actual laws themselves or the ability to enforce. And state immunity, sovereign immunity, and the access to remedies in domestic court is a function of global geopolitics. So the slightly unsatisfactory answer at all of the end of this is there may well conceptually be a whole range of ways of making a theoretical wrongdoer pay for injury, damage, loss that arises from negligently spreading an infectious virus around the world, as a matter of plain hard reality, unless and until the politics makes making China pay sort of possible, the law's going to find it very hard to follow that. So that's my slightly downbeat negative assessment. What would be useful now is to open up to any questions people might have. I've seen there's one Q&A here already. So are alternative dispute resources going to apply in this situation, and will it be sufficient? I mean, there are multiple levels that we can assess that. I mean, ADR at the broadest level encompasses a whole range of measures, so arbitration, mediation, a whole range of things. So I suspect there will be a range of negotiations, and again, this goes back to my political point. There is going to have to be some form of political settlement here. If it's possible, which there is a question as to that, there's going to have to be some form of political settlement here if people are looking to make the Chinese government pay. If we're then looking lower down the food chain to contracts that have been breached, to a whole range of wrongs that have been committed by non-Chinese state entities, but are arbitrable or give rise to legal claims, I think ADR is going to be as relevant as ever. Yeah, I mean, I don't know if there are any more questions.
Not yet, and we don't have any questions to YouTube stream. Maybe you can tell us something more about pandemic situation, about contract law in pandemic situation. Does it change a lot?
Well, that's an interesting question. In terms of controlling and was it? I mean, I think, and this is why I talked about sort of the various points that limit recovery of loss as a matter of English law. So contributory negligence, failure to mitigate. If you look at the US, if you look at the UK, I said it before, in Britain, we waited for 3 weeks. We watched with open eyes and ears as to what was happening in Italy and the mounting death rate and the lockdown and how awful it was, and we did nothing. So it's all well and good to say, well, China should have done something 3 weeks earlier, and almost certainly they should have done. But as a measure of damages, to the extent, let's kind of play a thought experiment. To the extent we find ourselves in The Hague at the Permanent Court of Arbitration, there is an arbitration going on under the international health regulations, under which China's a respondent and they are being accused of a failure to comply with their obligations to notify. Well, that's all well and good, but if you put your English law hat on and approach from an English law perspective, well, in public policy terms, what should have governments done? And that's going to bite in a whole range of ways, because different countries have approached this in different ways. They've adopted lockdowns early on, and that will have caused different measures of economic damage. And you look at Sweden, where there hasn't been much of a lockdown, but the death rate is higher. Does that mean that they've done it wrong, or have they done it better? So there are a whole range of issues here that really complicate any legal analysis. And I think that's what I was trying to get to in all of this, is that it's kind of an easy and sort of pithy political slogan for politicians to say, let's make China pay. But in terms of the actual legal mechanisms to do that, it's all very difficult. As you say, controlling it in different countries has been different. And there's been a sliding scale of responses of very, very good. And you look at South Korea, countries like Taiwan, New Zealand, who've contained it very quickly, very early. And you look at UK, US, I think Russia as well has kind of had a big spike recently. And questions will be answered in the fullness of time as to whether governments took the right steps at the right time, whether they were responsive enough, whether they did enough, whether they did too much, whether they killed the economy, and whether a lot of the loss and this £3.2 trillion, $4 trillion bill is actually not China's fault. It's the fault of the countries sort of stopping their economy and taking disproportionate action. So there are a lot of questions to consider, and it's just not. I think the key point I wanted to take home from all this is it's not going to be a pure question of legal analysis. Okay, got a question on remedies. Yeah, I think book or special articles help learn about the topic of remedies in more detail. There is a book. It's quite expensive. The first book that I would go to in terms of damages and recovering money as a matter of English law is a book called McGregor on Damages. And as I did for the last talk, I will do a reading list of books, articles, and cases that are relevant to circulate. But McGregor on Damages, which I will, I can't type in an answer. No, I can't type in an answer, but I will circulate a reading list. So McGregor's a good starting point. There are some good case law on it. And remedies is a really interesting area, and it was kind of the reason I ended up doing this quite high level is because you can go into it in a lot of detail in a whole range of ways. For example, my background before I came to Russia and became a more general commercial lawyer, I did a lot of intellectual property law, so patent infringement, trademark infringement. And when one talks about remedies in the context of intellectual property rights, we're not necessarily looking at money. The primary concern in a lot of those cases is an injunction. You want to stop the infringer, because if you're selling a drug and it's a patented drug and you can get $10 a pill, and an infringer's come onto the market and selling it at $1 a pill, that price erosion is causing you more damage than any loss of kind of immediate profits. So that's that. Okay, is it legally possible for the USA to cut the amount of debt as sanctions on China? I've seen this discussed. I'm not a US lawyer, is the starting point. I think the main problem, as I understand it on this, is the 14th Amendment to the US Constitution. And the historical context to that was a legacy of the US Civil War. It's one of the post-Civil War amendments where Congress wanted to make it impossible for the states that had seceded to deny the validity of debts incurred by the North in both fighting the war and then reconstructing the South after it. So there is an amendment to the US Constitution, which I think is quite simple, but it sort of says the validity of public debt shall not be questioned. So I think a lot of scholars think that that is a real problem in terms of cancelling or querying debt to China. I think China owns about $1.2 trillion in US bonds, in sort of treasury notes, in gilts, which is a lot of money. But until and unless someone could find a way around the Constitution, again, this reinforces the point that there's a huge political element to all of this, because the Constitution can, of course, be amended. But as I understand it at the moment, the Constitution of the US is a big bar to just sort of saying, well, we'll offset it. Whether there is some legal mechanism to sort of quantify the loss and then offset it in some kind of sort of set-off type claim, I don't know. And I'm sure a lot of US lawyers and legal scholars are looking at that right now. But I think the starting point is that constitutionally it's very difficult for America to do that. Okay, do we have any more questions?
No, I think that's all. Thank you for the lecture, and we all will be waiting for reading list.
Reading this, it's always a pleasure. Yeah, have a lovely weekend, everybody. It's quite sunny here. I hope it's sunny in Moscow as well. So yeah, have a good weekend, and I'll circulate reading list in the next few days. Thanks a lot.
Thank you.